Let's start. What are your guiding principles when it comes to judging a case?
You know, the bottom line is always fairness, impartiality, and looking at, what the rights are that the law was intended to protect. When people are in my courtroom, they're real people with real disputes and problems, and I always keep the people in the case front and center in making a decision.
There's a lot of attention on this race nationally, a lot of money coming in, a lot of partisan support on either side. How do you maintain your impartiality as a judge with all of that partisan attention?
Yeah, well, the way I look at it is that any legitimate organization or any individual who wants to support my candidacy, I welcome that. They just need to know that I will be fair and impartial. I'm not going to make any promises to them, and I am going to keep an open mind about any case that will end up in the Supreme Court, or is certainly those that are already in the Supreme Court. So if that's what kind of justice they want to see on the Supreme Court, I welcome their support.
Abortion access is a key issue for a lot of Wisconsinites this election. You've previously represented Planned Parenthood. How would you navigate an abortion access case in the state Supreme Court?
I would approach it the way I approach any case, really. I look at what the evidence is that the parties have brought to support their claims. I will analyze their legal arguments and consider the law from my own perspective, doing my own research on it. And on the Wisconsin Supreme Court, I would certainly listen to the perspectives of the other justices. The Supreme Court is a body of 7 justices, and I think it is really important to make sure I understand their positions before making a final decision on a case. That's how I approach every case, and that's how I would approach any case involving abortion access as well.
Would you describe yourself as pro-choice?
I am a mom. I have given birth twice and have gone through, pregnancy and labor. And when I was experiencing those things, I really wanted to make my own decisions about my health care and about my body and my family with my doctors. So, at a broad level, that's just something I really value. I think that most people want to make their own health care decisions after conferring with their doctors. So that's just kind of my general lens for looking at things like reproductive health care rights along with any other health care right.
There's been numerous instances of precedents being overturned here at the state level, with ballot box access being returned to the overturning of Roe v. Wade. Yeah. What do you factor in when deciding whether or not to overturn a precedent?
That's a great question, Vanessa. And what the law instructs us is that the courts have to follow precedent unless there's some very good reason to overturn it. And 2 examples I think that I can give you of when I think the United States Supreme Court got it right in overturning precedent, and one in which I think it got it wrong. First of all, Brown versus Board of Education. That case overturned a 19th century case that said that separate but equal is okay under the U.S. Constitution. Brown versus Board of Education threw out that prior case, saying separation on the basis of race is a violation of equal protection under our Constitution. And I think they got it right, clearly. A case in which I think the Supreme Court got it wrong is the Dobbs decision that overturned Roe versus Wade. They threw out a 50-year precedent that had protected women's rights to make their own health care decisions, to access abortion. And that was a constitutional vested right that they threw out. And I found their reasoning for throwing out that constitutional protection really inadequate. It means that, although generations of women have been able to depend on that constitutional right, people like my own 23-year-old daughter no longer have the same protections that I did at her age. So I think it's really important for courts to follow precedent and only overturn it if where there are circumstances where there's a really compelling need to provide protections for people under the law.
You've previously represented a group of teachers that were suing to overturn Act 10, and with Act 10 likely heading to the state Supreme Court, how does your history with Act 10 impact how you would navigate that case?
Yeah, well, I'm proud of the work that I did representing public school teachers when their rights in the workplace were taken away from them, fighting for them in court. And excuse me, if there's a future case in front of the Wisconsin Supreme Court about Act 10 and I'm on the court, I will certainly look at whether I can be fair and impartial in deciding that case. Act 10 was actually a 50-page long act that made many changes to many different parts of the Wisconsin statutes. And I believe the case that's working its way through the court system right now, although I haven't I haven't looked at the filings in that case or even read the circuit court decision in it. It involves a different part of the law than the one that I and my colleagues were challenging on behalf of Vanessa teachers, 10, 15 years ago. So I would make a determination based on the parties in that case and the particular legal issues that are raised, whether I could be fair and impartial in sitting on that case. That's not something I'm going to pre-decide now. It's not time to do that, and I don't have enough information to make that call. But I'll sit on any case on the Supreme Court in which I genuinely believe I can be fair and impartial, and I will take myself off if I don't believe it's possible for me to do that.
Speaking of taking yourself off, what specifically would your parameters be in determining whether or not to recuse yourself from a case?
Yeah, well, what the judicial rules require any judge to do, and what I do now as a circuit court judge, is to, bottom line, look at whether I can be fair and impartial in a case. There are some circumstances where recusal is mandatory, like if the judge has some personal stake in the outcome of a case, a financial stake, knows one of the parties involved in the case or has a close relationship with them. Otherwise, what the law requires is for a judge to make a determination on whether they can be fair and impartial. And I'll say that this is a big contrast with my opponent in this race, who has openly prejudged cases that are now in front of the Wisconsin Supreme Court, has been on record saying he thinks an 1849 abortion ban, criminal abortion ban in Wisconsin is perfectly fine and should be enforced. He has taken a position on that Act 10 case that's moving its way through the courts and has shown that he is not willing to be impartial. He's prejudicing the parties in that case by staking out his position, without even having looked at what the record is, what the evidence is, the facts or the law in those cases. I don't do that.
When Wisconsinites head to the ballot box on April 1st, what do you want them to think when they see your name on the ballot?
Yeah. Well, I want to have them think that this is a judge who is going to protect my fundamental rights and freedoms under our laws and under our Constitution, somebody who knows right from wrong, who will use common sense in interpreting the law, which is certainly the role of the Wisconsin Supreme Court, and that they will decide to choose me as an impartial justice over my opponent, who has a long record as a pretty extreme partisan politician who has worked throughout his career to take rights away from people.
Thank you so much for joining me today.
Thanks so much.